further ado, I am asking my own professor, Terry Calvani, who is off counsel to the prestigious law firm Freshfields. Thank you.
Delighted to be here this morning. I must say I begin most any presentation by saying I'm delighted to be here. And to be honest with you, sometimes maybe that's not altogether true. But today, I'm delighted to say that with great enthusiasm that I am delighted to be in Istanbul. It is one of the world's great cities. And so it is with great pleasure that I join you today in this marvelous venue. I'm also particularly honored to be here celebrating the 10th anniversary of ELIG. As Ganesh mentioned, I had the good fortune to have him in my class. At Harvard Law School, we have many bright, capable young people that go through the program, but I can truthfully say that there are none better than the senior partner of this law firm. Now, what I'd like to do today is talk briefly about cartel leniency. Sometimes young associates or students will say, Calvani, you've been at this for 40-some years. What are the most interesting developments that you've seen in your career? Which is a nice way of saying, Terry, you're an old man. What have you seen that might be of interest? And generally speaking, I say there have been two things that have happened in my lifetime in a professional sense. One of them has been the inculcation within competition law of industrial organization economics. And the second thing, which continues to this day, is globalization. I mean, there was a time not that many years ago when there were very few countries that truly played real competition law, and that's no longer the case. But there's another thing that maybe not of that sort of earth-shaking caliber as the advent of economics to competition law or globalization, but it is nonetheless important, and that is leniency. Because leniency has dramatically changed the way that cartel enforcement takes place around the world. Now, mindful that I stand between you and your lunch, I promise also not to take all of my time, but I'm going to very quickly go through the topics that are listed there on the agenda. One of the things I'd like to begin with is a slide that shows you the countries today that have cartel laws. That's truly phenomenal. Now, to be sure, there are countries that have laws on the books and maybe not much more. But that slide is rather dramatic. You notice, some of you will notice that, I can tell there'll be someone in the audience say, well, Malawi doesn't have a cartel law, but the fact of the matter is that some of those countries are highlighted in a lighter shade of yellow. For example, those are the COMESA countries, where the jurisdictions themselves may not have cartel laws, but if the conduct has an effect in two or more of those jurisdictions, there is a cartel law that governs their activities. But here's what I really want to focus on, leniency. Now, it's not as vibrantly colored a map as the previous one. There's a lot of white space there. But it is, I think, really dramatic when you consider the very few countries that had leniency programs in the not-too-distant past. So I'd like to begin just with my own country's leniency program. I'm not going to talk about it, but there are three features of it that have been copied by many different antitrust regimes. Sometimes they just take two, sometimes one, sometimes all three. Corporate immunity, that's the one that's, I suppose, most often employed around the globe, where undertakings have an opportunity to secure either immunity or leniency. Many jurisdictions, including, I think, Turkey, also provide individual immunity. That's a growing phenomenon as individual liability is increasing around the globe. And then lastly, something that's called Immunity Plus, which is probably present in a fewer number of jurisdictions. And for those of you that are not familiar with it, it is a program under which companies and undertakings that are currently under an antitrust investigation for cartel activity have an opportunity to reduce the penalty in the instant cartel under investigation if they bring to the authorities' attention another cartel in which the government or the agency may not already be acquainted with. It's surprising the number of cases that Immunity Plus programs have generated in the jurisdictions that have adopted it. But that's not where I want to stop. I plan to take a little time and contrast the US and EU models. I'm going to skip that. I'll just give you my bottom line, and that is that the differences are overstressed. With reference to undertakings, the programs are virtually identical. They're just different names that are given to them, and the U.S. immunity program has got to be read in light of other things. But those of you that are interested, we can talk about that later. So, I'd ask you to look at the numbers on the slides. 90% of the cartel cases in the United States are not developed by the Department of Justice. They're not developed by the Federal Bureau of Investigation. They are brought to the authority in a present with a bow wrapped around it, bringing in to the authority all of the facts of the underlying cartel. A big birthday present. The numbers are not quite as high in the EU, but they approach 80% at present. That is nothing short of dramatic. A generation ago, if a client found they had a cartel problem, obviously, legally, they needed to bring that conduct to a conclusion. But people could hold hands, calm down, take a deep breath, and the chances were that no one would ever find out. That has changed dramatically as exemplified by these numbers. And it's because of the instability that immunity programs interject in the way that corporations behave. There was one case in the United States where one immunity applicant followed another by 45 minutes. The first company gets off with no penalty. The second company with millions of dollars of fines and a chief executive officer going to prison for several years. Huge difference of this race to the agencies to confess. Now, it looks successful in Europe and in the United States. What about elsewhere? All of those colors on the map, are there really effective immunity programs in all of those jurisdictions? And the answer is no. The answer, in my view, needs to be approached by segregating international cartels from domestic cartels. The worst immunity program in the world will draw applicants if there's truly an international cartel at work. Generally speaking, and I've been on both sides of this fence. I was the director of the cartel portfolio when I was a member of the board of the Irish Competition Authority, so I've been on the prosecution side. But from a defense standpoint, if I have an international cartel, I'm representing a company, I'm going to seek immunity, let's say in the United States and the EU, I will generally seek immunity everywhere where the client does business and may have potential liability. I'll ring the doorbells of agencies who I would never knock on the door but for the international characteristic of that cartel. So what makes a difference? I think you need to look at the domestic attraction of a particular immunity program to assess its efficacy. And I'd like, with Frederick's permission, to draw on some of the teaching of the organization that he currently heads. And the OECD has several papers out on cartels, but I found this one particularly interesting because it underscores the importance of certainty and transparency in a leniency program. Let's take a look at a couple of leniency programs. This is one from a major, a very large country that with millions and millions of people. And I'd like for you to just take a look at this immunity program. Are you entitled to immunity? Every immunity case involves, that I've ever been part of, a presentation by me or by any one of the number of very distinguished practitioners in the audience to the board of directors, the executive committee of the undertaking, where they want to consider what are their options, and immunity is one of the options. And one of the questions that they'll ask is, what do we get if we ring the doorbell and go in and confess? And in this particular country, I would have to tell them that, well, I'm not real sure what we get, because this particular authority has reserved unto itself complete discretion as to what benefit the company, the undertaking, will receive, if any, at the end of the process. The applicant may be granted the discretion of the commission. The board of directors is going to say, Mr. Calvani, what protection can you tell us we'll get if we ring the doorbell? And in those jurisdictions, I would have to say, I don't know. And that's usually not a welcome answer to the board. Let's take another one. This is an immunity program that I administered. That was not my creature, but nonetheless, it's the immunity program that we had in the jurisdiction where I was responsible for cartel enforcement. And it divided the decision, a recommendation being made by the competition authority to a decision made by the public prosecutor's office. And here you see general discretion. Nothing in this program shall limit or otherwise affect the discretion of. The commission will make a recommendation. The director may decide. No board confronted with that language is going to readily ring the doorbell of that agency because of the uncertainty. So, you've got problems like in Ireland where the competition authority makes a recommendation to someone else and you don't know what that someone else might do. That's one problem. Another problem that Brazil had, for example, for some period of time was that there were independent players in deciding immunity. The competition people could give you immunity. You'd say, oh, thank you very much, we're so glad to have immunity. And they might say as you're walking out, well, of course, that won't stop the public prosecutor from prosecuting you and maybe sending you to prison. That would stop you as you walked out the door. You'd wonder, what is it that I've just bought into? I don't think this is such a good idea. And is there any little wonder why people didn't just rush down to ring that doorbell if what they're promised is immunity from the administrative agency, but there's the prospect of punishment and indeed incarceration by the public authorities. These are problems that exist around the world, and I want to suggest that to create effective immunity programs, as the OEC document, I think, tries to make this point, is that the authorities actually have to limit their discretion. There needs to be certainty in terms of what it is someone's going to get out of the program. And you know what's interesting about it? Is that the limitation of discretion in some sense makes the agency more powerful. Kind of a bizarre thing. I limit my discretion and I gain more power. I think that's the teaching of these immunity programs. There's another point, though, that also needs to be made. And I think this also, I can draw on my experience in Ireland, and that is the board of directors of the undertaking is always going to consider the counterfactual. What happens if I don't do it? Unfortunately, in many jurisdictions, the answer is, well, probably not much. This was the problem with the immunity program in Ireland. Yes, we'll give you immunity, but what if I didn't even come down there? What bad thing would happen to me? And the answer was, in general, probably not much. I want to skip quickly to these slides in the US, and there are other jurisdictions I could have picked, but I'm going to pick the one that I'm most familiar with. Last year, the fines in the United States exceeded $1.86 billion. That's with a B. That's a lot of money. Terms of incarceration now approaching 3 years terms of imprisonment on average. Those are severe sanctions. The slides on the board reflect those jurisdictions that today, at least on paper, have custodial sentences. Big flags indicate jurisdictions that provide it for all cartel offenses. Small flags represent those jurisdictions where certain kinds of cartel offenses are actionable. I'd like to bring us back some couple of centuries ago and remind us of a teaching that I think is oftentimes forgot by competition agencies, and that is that the penalty must be adjusted by the probability of detection and punishment. It is not a good day for a competition authority to say, by virtue of a fine, we've recovered all of the ill-gotten gain. That makes sense only if you're pretty sure you're going to capture each and every cartelist. Now, I don't stand behind this study because I haven't gone through and tried to replicate any of it, but it is one of the most interesting studies, I think, to come out of economic work on competition policy in some time by two French economists. And they found in studying EU fines, and again, I don't know whether you played with the numbers, whether it comes out, whether they've done their math right, but it is an interesting point, and that is that in 50% of the cases handled by the European Commission, fines were below the illicit gain. If that is true, then the cartel, the competition authority, is simply a stakeholder in the cartel. It's just a partner with the cartelist. You keep $100 million and we'll take some money in a fine. And we're both happy. We've got a big fine and you made some money. Just the cartelist and the competition authority in partnership together. So, interestingly, they found only one case where the fine was sufficient to deter. And again, I'm not saying that the study is gospel, but I am saying, I think you ought to maybe take a look at it. It's an interesting study. I want to make, I promised to finish out here in a minute, and I'm going to do that. I'll keep to my promise. But I just want to remind you of what it is that a board of directors does when it confronts the decision of what do we do now that we found cartel behavior. And it is something like this. It may not be articulated in this way, but this is what the businessmen and businesswomen think about when you go to make this presentation. And the decision to seek immunity is not costless. It can be hundreds and hundreds of millions of dollars. So the decision to seek leniency isn't an easy decision unless you've made the decision you're going to seek it elsewhere. And that's why I want to suggest to you this kind of separates immunity programs that work from immunity programs that don't work. So you need to weigh the cost and benefits. And this brings me back to the certainty and transparency points in the OECD documents. Those are ever so important. And I remember talking with competition authorities, competition officers, in the very first slide I showed of the very first immunity program, and they said, why doesn't anybody come knock on our door? Why doesn't anyone come confess? And my response was, you need to go back and read your leniency program. Penalty, clarity, certainty, and priority. Well, I think in the light of the hour, that I'll stick to my promise and not keep you from your luncheon, and I'd be delighted to answer questions over the lunch hour. Thank you very much.